All right, I'll hear from you in a moment. Yesterday, one issue that was before the court was the state's objection to the testimony of Dr. Hamra. And I have, as indicated, I have researched that issue, have prepared a written order that is in nearly final form and that I will read into the record in a few moments. So that's the first order of business that we'll have today. Mr. Fawcett, anything?
Not from the state, Your Honor.
All right, on that issue, Mr. Arbor?
Yes, Your Honor. The defendant will respectfully submit on behalf of the defendant and ask the court to receive it and make it part of the court record a memorandum of law. With respect to this issue, may I approach you?
Yes.
I provided Mr. Fawcett with a copy of this
Thank you.
memorandum. It recites 4 cases from the state of North Carolina, all stating that Dr. Hammer's testimony as offered would be that of a fact witness and not as an expert witness. I'm happy to be heard on the 403 issue whenever you're ready.
I'm going to read, I've looked through the 3-page memorandum that you've handed up and I'm familiar with the cases attached to it. I'm going to read this order into the record. And like I said, I'll be submitting a written copy of this order, so if you'll bear with me, I have some findings and conclusions that need to be made part of the record. So this matter comes for the undersigned. Upon the defendant's forecast of evidence and the state's objection thereto, the court has considered the arguments of counsel and the record proper and makes the following findings in conclusion. This matter was called for trial February 23, 2015. On about February 23, 2015, prior to jury selection, defendant, pursuant to North Carolina General Statute 15A-905, parens C, parens 3, and 905, parens D, provided the state with a witness list that included the name Badri Hamra, that Dr. Badri Hamra is a psychiatrist employed by the North Carolina Department of Public Safety. He provides psychiatric care to inmates confined in correctional facilities, including Craven Correctional Institution. On December 19, 2013, the state filed and served a request for reciprocal discovery and an alternative motion for reciprocal discovery, wherein the state requested the defendant provide, among other things, notice to the state of any expert witnesses that the defendant reasonably expected to call as a witness at trial, as well as reports or results of examinations or tests conducted by the expert and the expert's curriculum vitae, opinions, and underlying bases for those opinions. On or about April 17, 2014, the Honorable Donald W. Stevens entered an order that required that reciprocal discovery from the defendant be provided by May 30, 2014, along with any notices of defenses. On or about June 25, 2014, defendant's counsel, citing among other things that defendant had been moved from Central Prison in Raleigh to Craven Correctional Institution, requested that the deadline for filing such notices of defenses be extended until August 14, 2014. With the state's consent, Judge Stevens entered an order on June 25, 2014, ordering that defendant be given until August 14, 2014, to file any defenses in this matter and comply with reciprocal discovery regarding expert witnesses, end of quote. Defendant filed no notices of defenses and did not provide notice of any expert witness, nor any expert reports, examination or test results, curriculum vitae, opinions, or underlying bases for those opinions. On March 16, 2015, the state rested its case in chief. Defendant announced that its first witness would be Dr. Badri Hamra. Based on the state's objection to any expert testimony from Dr. Hamra, the court permitted a voir dire examination of Dr. Hamra outside the presence of the jury. The following evidence was forecasted through the voir dire of Dr. Hamra: that Dr. Hamra has been a psychiatrist with the Department of Public Safety for 10 years and as such treats prisoners in need of psychiatric care, that Dr. Hamra treated the defendant beginning in July 2015 at Craven Correctional Institution. When asked whether he prescribed medications for inmates if he believes it helps their mental condition, Dr. Hamra responded that it did. When asked whether he prescribed medications to defendant to deal with his mental conditions, Dr. Hamra responded that he did. When asked to describe the medications prescribed, he testified that he prescribed Effexor, Zoloft, Buspar, and Risperdal, and that these medications were used to treat individuals with anxiety, psychosis, and depression. Dr. Hamra testified that when defendant was transferred to Craven Correctional Institution, he evaluated defendant and reviewed a summary of his medical records provided from Central Prison so that Dr. Hamra could make his own determination of defendant's need for medication. Dr. Hamra testified that he noted that defendant was on these same medications while housed at Central Prison. He made the determination defendant should remain on these same medications after his transfer to Craven Correctional Institution. As such, Dr. Hamra continued to prescribe the same 4 medications for defendant. Dr. Hamra testified that defendant has continued to be on these medications until the present date. Dr. Hamra stated he would not prescribe these medications unless he believed they were needed. He would not prescribe them just because defendant asked for them, and that he would only prescribe them for legitimate medical reasons. Dr. Hamra acknowledged that in the course of his treatment of the defendant and in preparation of his testimony at trial, he reviewed summary medical records from Central Prison and that he maintained his own records at Craven Correctional Institution. Dr. Hamra's records were not with him in court on March 16, 2015, and the records he reviewed or created have not been provided to the state by the defendant. Counsel for defendant, while acknowledging awareness of the obligations of reciprocal discovery pursuant to NC General Statute 15A-905 and the orders of Judge Stevens, assert that they elected not to file notice of this witness, other than including him on the defendant's witness list, because the witness was merely a fact witness and not being proffered or tendered as an expert. The state objects, arguing that the testimony of Dr. Hamra is opinion testimony, which may be offered solely through an expert, that it is not relevant, and even if relevant, it should be precluded under Rule 403 of the North Carolina Rules of Evidence. Defendant does not assert that their decision not to designate or disclose Dr. Hamra as an expert or the decision to offer his testimony at this time was made more acute by any surprise or unforeseen development during the state's case in chief. Rather, from the outset of this trial, defendant has steadfastly maintained that his primary defense to the indicted offenses was that defendant, in a depressed and suicidal state of mind, snapped and assaulted the victims without premeditation. The initial issue before the court is whether the proffered testimony of Dr. Hamra, as forecasted in the voir dire, constitutes the testimony of an expert witness and is therefore subject to the requirements of General Statute 15A-905C2, Judge Stevens' reciprocal discovery orders, and Rule 702 of the North Carolina Rules of Evidence. Our appellate courts have held that if the subject matter in dispute is beyond the general understanding of a jury, a party bearing the burden of proof must adduce expert testimony to explain such evidence. This is in accord with federal case law that defines and expounds on expert testimony. Expert testimony results from the process of reasoning that can only be mastered by experts in the field. Here, Dr. Hamra, a psychiatrist, is being proffered by the defendant to testify that he believed that Effexor, Zoloft, Buspar, and Risperdal, used to treat individuals with anxiety, psychosis, and depression, were helpful to the defendant, needed by the defendant, and only prescribed for legitimate psychiatric reasons. He is offering an opinion extending beyond that of a mere treating physician, but rather one that implicitly evaluates and endorses a course of treatment that defendant has received throughout his confinement at Central Prison and beyond. And by definition, a psychiatrist is a medical doctor with specialized skills, training, and experience in diagnosing and treating, including the prescription of medications of mental illness. The court finds and concludes that the subject matter of this testimony, namely the diagnosis, treatment, and medications associated with mental illness, is well beyond the understanding or the ordinary understanding of a jury and must, if it is to be offered at all, be offered by the defendant through an expert properly qualified under Rule 702 of the North Carolina Rules of Evidence to render such an opinion. Because the court so finds, the court must also find defendant's decision not to disclose the intention to call Dr. Hammer to render this testimony is contrary to the clear requirements of General Statute 15A-905C2 and Judge Stevens' reciprocal discovery orders. Defendant's decision not to disclose Dr. Hammer as an expert witness in a timely fashion deprives the state of the opportunity to evaluate Dr. Hammer's credentials, his reports and conclusions, the results of any tests or examinations he performed, his opinions, or the underlying basis for his opinions, and if need be, have him evaluated by an expert chosen by the state. Moreover, the defendant's decision not to disclose Dr. Hammer as an expert witness in a timely fashion hinders the court's ability to fulfill its gatekeeping obligations under Rule 702 of the North Carolina Rules of Evidence because the competency of the expert opinions proffered by Dr. Hammer cannot be fully evaluated without the opportunity for a fully informed direct examination by the defense and an equally fully informed cross-examination by the state. The court has also considered under Rule 401 of the North Carolina Rules of Evidence the relevancy of Dr. Hammer's proffered testimony, that at the time he examined the defendant in July 2014, he concluded that the 4 prescribed medications would be helpful and needed by the defendant. The criminal acts alleged against the defendant occurred in April 2013, 15 months prior to Dr. Hammer's evaluation of defendant at Craven Correctional Institution. Even if this information were viewed merely as a fact, as urged by the defendant and not expert opinion, the observations made by Dr. Hammer and the events that are the subject of this trial are simply too remote in time and therefore not relevant to the issue of defendant's mental condition at or around the time of those events. Finally, the court has considered under Rule 403 of the North Carolina Rules of Evidence whether even if the offered testimony of Dr. Hammer were relevant to Rule 401, the evidence should nonetheless be excluded because its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. Upon such a balancing, the court finds that the proffered testimony of Dr. Hammer's should be excluded because, under the circumstances that the defendant has decided to attempt to offer it, the state is unfairly prejudiced by its inability to adequately prepare for cross-examination of Dr. Hammer, or, if it wished, proffer a rebuttal witness refuting his findings. Likewise, the naked testimony of Dr. Hammer that medications were required and helpful to the defendant without being subjected to the strictures of Rule 702 would have the substantial likelihood of confusing the issues of this case, misleading the jury, and would invite the jury to speculate as to the nature of these medications, the nature of the conditions these medications were used to treat, the reliability of the diagnosis, the duration of the conditions, and the effect of these conditions upon the defendant's state of mind and credibility at any time relevant to the alleged criminal conduct. So for each of these reasons, independently and collectively, the court finds and concludes that the testimony of Dr. Hammer regarding medications prescribed to the defendants, the conditions treated by those medications, any psychiatric diagnosis of the defendant, any course of treatment of the defendant, and any beliefs or opinions that he has about defendant's mental state is inadmissible and must be excluded. So that would be my ruling in this matter. I'll be glad to hear from you, Mr. Arbor, if you have anything that you wish to add, sir.
Yes, sir. Respectfully, the defense will ask the record to reflect that the order of the court is reflective of normally an issue of whether or not evidence is submitted for 403 purposes is reviewed on an issue of abuse of discretion. In this case, we would respectfully submit that the court's ruling, although it references 403, and we would respectfully submit incorrectly, is in error on a larger scale, on a legal scale, not on an abuse of discretion scale, because the court has premised its opinion on the basis that Dr. Hammer's testimony, which has been offered through the offer of proof and is entered into the record of this court, is evidence of expert opinion subject to the parameters of 15A 905C, 15A 905C2. We have submitted this morning to Your Honor a memorandum of law and 4 cases from the state of North Carolina that have recognized that a physician who is testifying only as to the treatment of a patient is a fact witness and is not an expert witness. Therefore, he is not subject to the provisions of 15A 905C2. So that we would respectfully submit as a legal error by the court in recognition that these statutes apply. The designation of him as an expert is respectfully, in our opinion, an attempt to try to prevent what would be extremely probative evidence to the jury of evidence that the state introduced and creates an extreme prejudice to the defendant, an unfair prejudice to the point where it now deprives him of his right to a fair trial, proper confrontation of the evidence, and due process under both under all 5th, 6th, and 14th Amendments of the Constitution of the United States. He has to be able to confront testimony that's offered by the state. The state could, and I point this out, because as the state is saying, we can't call him without, because we didn't give notice, and we respectfully disagree as to whether or not he's an expert opinion, and I suppose that'll be for higher courts to decide whether the right decision has been made here. But in any event, they elected to put in a portion of a confession of our client that incorporates I will say a statement from my client, which is substantive evidence. And we've already given our motion that the court has erred in not requiring the entire statement of the other 2 statements to come in, and has erred in not allowing us to properly cross-examine the witness, Detective Morse, with respect to the differences that occurred in the earlier statement and the later one. But nevertheless, on the 26th of April, that was submitted by the state. The state does not have to limit itself to calling a doctor solely upon the actions of the defendant. I would remind the court that the state could have called a doctor to testify to render an opinion as to whether or not that evidence in that exhibit regarding his being depressed, regarding his being anxious, regarding his hearing voices, could have called a doctor on their own, not as a witness who's testifying having examined Mr. Broyhill. That would have been triggered had we filed a notice of an NGRI or a diminished capacity. But they could have sought to call the opinion of an expert witness, a doctor, a psychiatrist, or a psychologist, regarding the behavior and whether that was consistent with the conduct that here. I suspect they didn't, because the conduct is consistent with someone who is suicidal, who is depressed. That's why they didn't call an expert. But they could have. Respectfully, it is the state who has been housing our client. It is the state who has, under Kyles v. Whitley, access to all of the government records. It is the state who housed him as a safekeeper in Central Prison from the day that this thing happened. It is the state that moved him from Central Prison to Craven Correctional Facility. The reason that the state put him in those facilities is because they felt he was potentially a person who could harm himself or in fear of harm of others. They put him in that facility because they thought he needed medical care, that he needed psychiatric care. They are the ones who provided it to him. They are the ones who have been treating him. It is Dr. Hamra, who's in the courtroom, who works for the same government that the state works for that is prosecuting this case. To come in here and say that the state isn't on notice, that he's not having these issues dealt with, is ridiculous, because they're the ones who put him in there. They didn't hold and the court knows this, a regular defendant in a murder trial not having these issues would be held at the Wake County Jail. In this instance, Mr. Broyhill has been held by the state from the day this thing happened, from the time he left Wake Med. He went probably for a moment or a day, from what I recall the records, to Wake Med, to the Wake County Jail, because he was immediately transferred to Central Prison, where there was a hospital that could deal with both his physical injuries that he had sustained and his psychiatric issues. His medical issues healed, and yet they didn't remove him from safekeeping. In fact, in the beginning of July, I believe, as Dr. Hammer testified in 2014, they moved him from Central Prison to Craven Correctional Facility. Mr. Fawcett has known this because in preparation of this case and in past appearances before Judge Stevens at the homicide status conferences, I've mentioned on a number of occasions that our ability to represent Mr. Broyhill was impaired by the fact that we had to go to Craven Correctional Facility, which is out toward New Bern, just to see our client, to prepare this case. So for the state to say that they had no notice that he was receiving psychiatric care, that a witness might come in here saying that he receives the medication, is absurd. And for the court to sanction it in such a way as to prevent Mr. Broyhill from being able to present a fair defense, a defense to these allegations against him, respectfully is more than an abuse of discretion. It's an abandonment of the court's role to make sure that this defendant is entitled, gets a fair trial. I've said it before. Respectfully, because of this ruling, I will renew my motion for mistrial.
Mr. Fawcett, do you wish to be heard, sir?
No, Your Honor.
All right. The motion for mistrial is denied.
Note my objection.
Yes, sir.
Your Honor, based upon the court's ruling then, and since I don't think the court has demonstrated it is going to entertain any further argument, may we release Dr. Hammer so he may return to his patients at Craven Correctional Facility.
Mr. Fawcett, any
No
objection?
objection.
All right, yes, sir. You may release him from his subpoena. He's free to go.
Thank you, Dr. Hammer.
All right, very good. Are there any other matters that we need to take up outside the presence of the jury? All right, very good. Anything else?
Judge, just as we've informed you, after court yesterday, counsel contacted us about adding a witness to their list to call us more, and the state told them last night the state has no objection.
All right.
Your
That's
Honor, we
fine.
do have one additional name for the record, Amy Cardwell. We notified, as counsel said, we notified the state last night.
That'll be fine, thank you. If there's nothing further, let's go ahead and bring jurors, please. I dealt with the matter outside the presence of the jury. I believe we are ready to ask whether there is further evidence for the defense.
Yes, Your Honor, the defense calls Daryl Broyhill to the stand.
Hand on the Bible and raise your right. Do you solemnly swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You may be seated.
Mr. Arbor? I'm sorry, Miss Elliott?
Thank you, Your Honor. Good morning, Mrs. Broyhill. Can you introduce yourself to the jury?
I'm Daryl Broyhill
And where do you live, Mrs. Broyhill?
in Lenore.
Who do you live with?
Kenneth Broyhill.
And what is your relationship to John Broyhill?
He is my stepson.
And are you married to John's father?
Yes, ma'am.
When did you marry John's father?
In December 2003,
And how old was John?
22.
Where did you and Mr. Broyhill move when you got married?
I moved into his home.
Was that in Lenore?
Yes.
And who was living in the Broyhill home when you moved in?
Jonathan and Becky.
And how old was Becky at that time, if you remember?
She's 3 years younger than John, so
19?
19.
What was your relationship to John when you and his father got married?
We were friends, very close.
Was that right away?
Yes, ma'am.
Can you tell us a little bit about John when you and his father got married?
He was very happy-go-lucky, a great personality, very loving, caring.
Where was he working when you and his father got married? If you remember.
Lowe's Foods.
And was he working there full time?
Yes.
When you said Becky was living in the home then as well,
Yes.
and how long did she stay living there?
Approximately 2 or 2.5 years. She lived with us until her mother bought a home.
And then where did she go after that?
She moved in with her mom and then spent weekends with us.
And is that still the arrangement now?
No, she still lives with her mom, but she comes and has dinner with us usually on Monday and Tuesdays and Thursdays.
Going back to close to the time after you and Mr. Broyhill got married, did you and John spend time together?
Yes, we did.
What were the types of things you would do?
We would go out to eat together. We cooked together. And some evenings we just sit on the deck and talk and listen to music.
Did you and John have a closer relationship than you and Becky?
Yes.
Were you aware in the years that followed after you and Mr. Broyhill got married, were you aware that John filed bankruptcy at one point?
Yes.
Did you know how much money he was in debt?
No.
What were you aware of about that?
He had leased a vehicle, and the lease ran out, and the mileage exceeded what was expected, and there was a large amount of money due. Felt like that was the main reason, was that indebtedness.
Was there other debt as well that you were aware of?
I think there was some credit card debt also.
And John was still living at home when that happened?
Yes.
Besides the lease on the vehicle, could you see what he was spending money on?
Not really. He liked to dress well. He always had nice clothes. He liked to eat out, and he liked his Starbucks coffee, that type of thing.
You described your relationship with John as close.
Yes.
Did John ever tell you that he was gay?
No.
When did you later come to learn that he was gay?
Yes.
Do you feel like that is something he would have shared with you or his father?
No.
Why not?
I think because of our Bible beliefs, that he would be almost afraid to come to us and tell us that he was gay.
You think that would have been a hard thing for him?
Oh, yes.
Over the years, before John moved to Raleigh, did you see whether John had or can you describe John's relationship with his mother?
It was estranged. He did not have a real relationship with his mom.
And once he moved to Raleigh, did he, when he would come back to visit, would he see his mother?
Not to my knowledge.
Were there discussions in the Broyhill home about his mother's relationship with Sarah?
Yes.
And was there a belief in the home about that his mother had a romantic relationship with Sarah?
Yes.
Did you have discussions with John about his mother's relationship with her?
Yes.
What did those discussions with John center on?
John told me that he felt that his mother had chosen Sarah over her own family.
Could you tell whether this was upsetting to John?
Yes.
How could you tell?
He teared up.
Did this happen on multiple occasions?
Yes.
Did you believe that his mother's relationship with Sarah was one of the factors that caused his estrangement with her?
Yes.
Did you ever see a change in his relationship with his mother?
No.
Do you or your husband have, what is the nature of your or your husband's relationship with his mother?
We don't have any contact, any communication.
Mrs. Broyhill, over the years, did you meet Nation Han?
Yes.
Can you tell the jury about that?
I think the first time I met Nation, he came over. It was a holiday, and he ate with us. He just dropped in, and we were getting ready to eat, so he ate with us. And then I met him again at he and Jamie's engagement party. And then probably a year or so before this incident happened, we all met in Pigeon Forge for a weekend.
And Nation Han and Jamie Han were there, is that right?
Yes.
And do you also know Nation Han's parents, David and Pat Greer? There's been testimony about Whitnell Pentecostal Church. Are you and your husband members there?
Yes.
Mrs. Broyhill, can you tell us about finding out about these events on April 22nd, 2013?
We received a call from our pastor, and he gave Ken Nation's mother's cell phone number and told him that he needed to call her. And they were, Pat and David were on their way to Wake Medical Center. And she told us that John had been embezzling money from Jamie's company, and that he had stabbed Jamie and Nation and had tried to kill himself, and that Jonathan and Jamie were in surgery.
And what did you do?
I called Becky to tell her so she could tell her mother, and then we left for Raleigh.
What time did you get to Raleigh?
12:30 or 1, I'm thinking.
And where did you go?
We went to the emergency room entrance.
What happened when you got there?
I asked information about Jonathan Broyhill, and they did not have him listed as that. And she made some calls, and the officer came down and took us into a little room and talked with us.
And what were you told at that time?
That John,
To explain the conduct on it.
Members of the jury, I'm allowing this testimony of an out-of-court statement solely for the purposes of describing or explaining what happened next. It's not to be considered by you for the truth of what's said, but only to explain the next thing that this witness did. Go ahead.
he told us that John was coming out of surgery and that he would be all right, that Jamie was still in surgery. And we asked if we could go see Nation and David and Pat. And he told us no, that the best thing we could do would be turn around and go back home, that John was under arrest and we would not be allowed to see him.
And what did you do next?
We went back to Lenore.
When was the next time you saw John?
In July.
Before we get to that, Mrs. Broyhill, you have several children from a previous relationship, is that right? And does one of your daughters have rheumatoid arthritis?
Yes.
Did you come to learn something about that after these events?
After these events, she told me that John had told her that he had RA also.
Did you find out when that happened?
The Easter before he moved to Raleigh.
Do you remember approximately when he moved to Raleigh?
No, I don't. I don't remember the year.
I think it's come out in testimony that that would have been around the fall of 2009. Does that sound about right?
Yes.
Did John also tell you at some point that he had rheumatoid arthritis?
Yes.
Do you recall when that was?
It was the first time he came back to visit after he moved to Raleigh.
You said the next time you saw John after these events was in July of 2013.
Yes.
Where did you see him?
Central Prison.
Can you tell us about that meeting?
It was very emotional. John seemed to be in his own world. He found it hard to keep a train of thought, and he had just a blank expression on his face.
What do you mean he seemed to be in his own world?
He didn't seem to be connecting with what was being said.
When you say it was emotional, was it who was it emotional for?
For his dad and I.
Did John show any emotion?
None.
Why did it take so long to be able to see him?
We had to wait until Jonathan sent us the papers to fill out to apply for visitation.
Did you see him again after that?
Yes.
How often did you see him while he was at Central Prison?
Every month.
And then we've heard testimony that he got transferred to Craven Correctional.
Yes.
Did you also see him once he went to Craven Correctional?
Yes.
How often did you see him then?
Approximately every 6 weeks.
Can I have just a moment, Your Honor?
Yes. cross-examination? All right, thank you, ma'am. You may step down. Further evidence for the defense?
Yes, Your Honor, the defense calls Amy Cardwell to the stand.
Ma'am, if you would please stand, place your left hand on the Bible and raise your right. Do you solemnly swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Ms. Elliott?
Thank you, Your Honor. Good morning, Ms. Cardwell. Can you introduce yourself to the jury?
Amy Cardwell. I'm John's stepsister.
And we just heard from Daryl Broyhill. Are you her daughter?
Yes, ma'am.
Mrs. Cardwell, do you have any medical issues?
I have multiple sclerosis.
When were you diagnosed with that?
2006.
Is that common knowledge in your family?
Yes.
And I think we heard from your mom that she married John's father in 2003.
Yes.
Have you had, since that time, would you have had opportunities to have family gatherings and such with John?
Yes, ma'am.
And would he have been aware that you've been diagnosed with multiple sclerosis? Did there come a time when you had a conversation alone with John about your MS?
Yes.
Can you tell us about that?
It was at the funeral home when John's grandmother had passed.
Approximately when was this?
I am not good with dates. Part of the MS, I get confused with time frames. Several years ago.
I think we've heard, this was when his father's mother
Mother
died.
died,
I think we've
yes.
heard testimony that was in January 2013.
Sounds right, yes.
Okay, go ahead.
We had gone out to the car to smoke, or for me to smoke, and he asked me not to say anything to any of the other family, but told me he had been diagnosed with MS.
And what else was said in this conversation?
Asked him what treatment he was on. He said Avenox. Said I asked, what brought about him being diagnosed, and he said balance issues and had had a lumbar puncture to confirm it.
Did he tell you when he had been diagnosed?
It had been recent to the feeling I got. He didn't say exactly when.
And I believe you said he asked you not to tell his father.
Yes, ma'am.
Approximately how long did this conversation last?
30, 45 minutes we were out there.
And was the conversation primarily about the multiple sclerosis?
Mm-hmm. Yes, ma'am.
Did you tell anyone about this conversation about what John had told you?
I had spoken with my husband about it, but I didn't mention it to anybody else.
Did there come a time that you did tell anyone else?
Yes.
When was that?
After everything happened, I spoke with my mom.
Just a moment, Your Honor.
Yes. cross-examination.
Ms. Cardwell, I just didn't hear, did you say it was balance issues and a lumbar puncture? Was what your understanding of the
Yes, sir.
reason that brought the diagnosis? Okay, I just didn't hear. Thank you.
Anything further, Ms. Elliott?
No, Your Honor.
All right, thank you, ma'am. You may step down. Further evidence for the defense?
Yes, Your Honor. The defense calls Susan Simon to the stand.
Stand.
If you would, please place your left hand on the Bible and raise your right. Do you solemnly swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Ms. Elliott?
Thank you, Your Honor. Good morning, Ms. Simon.
Good morning.
Can you introduce yourself to the jury?
I'm Susan Simon. I'm a nurse psychotherapist in private practice in Raleigh, North Carolina.
And what does that mean?
I have a graduate degree in psychiatric mental health nursing, and I'm certified to provide counseling and psychotherapy services.
And how long have you been in practice?
In Raleigh, I've been in practice since 1987.
Did you come to know Jonathan Broyhill?
Yes, I did.
When was that?
He first came to my office on February 8th, 2012.
And how long did you see Mr. Broyhill?
Till about May of 2012.
Do you recall approximately how many sessions you saw him for?
Yes, about 10 sessions.
How long did each session last for?
Anywhere from 50 to 60 minutes.
And is this something that he would have just contacted you for and asked for a session?
Yes, he called and asked for a session.
I'd like to ask you some questions about your sessions with him. Would it refresh your recollection to take a look at your notes from those sessions?
Mm-hmm. Yes, thank you.
May I approach the witness, Your Honor?
Yes.
Ms. Simon, I'm handing you what's been marked as Defendant's Exhibit 22. Can you tell me what that is?
This is the initial forms that I have, that I had John fill out when he first came to my office, and as well as copies of the records of my notes that I would write when during the session, as well as maybe as soon as he left, I might add something else into the notes.
And are these something you keep in the normal course of business when you see patients?
Yes, I keep notes of every session that I have with a client.
And I believe you said that the first session you saw John was February 8th of 2012?
Yes.
And what was the last session you had with him?
May 29th, 2012.
Over the course of the, I believe you said 10 sessions you had with John, did you come to note certain themes in your sessions with him?
Yes.
What was one of those themes that you saw in him?
He talked a lot about not feeling good about himself, feeling worthless, feeling unattractive, not feeling that he couldn't find a place for himself within the gay world. I can tell you, he talked about having a history of participating in unhealthy relationships with other men. He complained about low self-esteem. He felt like he had some sexual identity issues. He complained about being depressed, about being anxious. He was unhappy. He was shy.
And were these, did these arise in most of your sessions with him?
Yes, yes.
Did he talk about, being self-conscious about his appearance?
Yes. He talked about being overweight. He talked about not feeling good about not having hair. He talked about not being attractive. He felt that when he was in a gay environment that he didn't look like the typically gay man that was healthy with beautiful hair and tan and fit. And he didn't feel that he fit into that kind of environment.
Did he talk to you about being lonely?
Yes, yes. He had just broken up from a long-term relationship. It wasn't a healthy relationship. And he was coming up to his 30th birthday, and he was sad that he didn't have anyone in his life. And also Valentine's Day was coming up, and he really was wanting to have somebody special in his life.
What about issues with his family? Did he talk to you about his family?
Yes. He talked about having grown up in what he called a dysfunctional family. He felt that his mother was unavailable to him when he was a child, that she should never have had kids and that she never really wanted to have kids. He felt like when he was a child, he was seen but not heard, and he was never good enough. Even when he did well in school, his mother's response would be, "You could have done better." So, for example, if it was a salutatorian, his mom would ask him why he wasn't valedictorian. He didn't spend a whole lot of time talking about his father. He talked most of the time about his mother. He also talked a lot about growing up in a fundamentally religious environment and how difficult that was for him because he didn't feel like he fit in. And from that came out the idea that because he was gay, that he was demon-possessed, that he must be demon-possessed.
Did he talk to you about any losses he had suffered?
Yes. He talked about, he had a really positive and loving relationship with his grandmother, and how sad it was for him to lose her. And then he talked about having two friends who he'd recently lost also. And then an aunt around the same time had died also from cancer. That was a little bit unexpected.
Did he tell you about any abuse he had been through?
Yes, somewhere in the middle of our times together, he talked about how he was sexually abused by his uncle, who was a Vietnam vet. And this abuse started at the age of 5 and continued till the age of 10 when his uncle had died. He never told anyone. And when he was young, he thought it was normal. And it wasn't until he was a teenager that he finally figured out that it wasn't normal. And he was struggling with how to view that. As a child, he enjoyed the time together with his uncle. He felt like it was the only attention he was getting. And so he was having some memories and some flashbacks about that experience, and he was having a lot of difficulty managing with the experience.
You said your last session with John was May 29th of 2012, is that right?
Yes. Mm-hmm.
Did you have another session scheduled after that?
Yes, we had a session scheduled for June 12th. He didn't come. He didn't show up. So I called and left him a message to reschedule. And then he didn't return my phone call, so I called him again on June 19th to try to reschedule, and he didn't call back either.
And did you ever hear back from him after that?
No.
Simon, when he talked to you about the abuse that he went through from his uncle, did he talk to you about whether, at the time, what he thought about the behavior?
Well, initially as a child, he thought it was normal. As he turned into adolescence, he realized it wasn't normal. He was struggling with the fact that he cared a lot about this man, and he felt like it was the only man that treated him, well, not the only man, but a family member that was treating him in a loving way. And so he was struggling with not being angry at the uncle, the way that he was trying to cognitive understand what happened. So he was trying not to be angry at the uncle and believed that his uncle was fucked up. sometimes he felt like he was in a cloud. So he was definitely struggling with it at various times in the present.
Ms. Simon, do you recall, or I think it's in your notes under the client information questionnaire, you have a section on the insurance information,
Yes,
and you have listed private pay.
yes.
What does that indicate?
He was paying me, he was not using insurance, he was paying me out of pocket by cash.
You used a term, fucked up. Would that have been,
Quotes, quotes.
those would have been John's
His
words?
right.
Cross-examination, Mr. Foster.
All right, may the state have a short break to review this 17-page document that was just given this morning.
That'll be fine. Ladies and gentlemen, we'll go ahead and take a mid-morning recess at this time, and we'll resume at, let's just say, 10 minutes past 11. Please don't talk about the case among yourselves or with anyone else. Please don't form or express opinions about the outcome. No media or independent investigation into these matters, and please have no conversation or communication with parties, witnesses, or lawyers. Leave your notepads and gather at 10 past 11. Everyone else, please remain seated. To take up for something.
From the state.
All right, we'll be in recess till 10 past. Ma'am, you must step down.
Fair Court of